Welcome to the second webinar in our 5th annual Melbourne Forum on Constitution Building in Asia and the Pacific. I'm Amanda Katzberl and I'll be the moderator today. I work for International Ideas, the Regional Advisor for Constitution Building in Asia and the Pacific. As part of this role, I've been honored to be involved in the Melbourne Forum since 2017, and it's been wonderful to watch our community grow and to learn from and work with all the impressive Melbourne Forum members, many of whom are joining us today, as well as the Con-Transnet at Melbourne Law School, who's International Ideas partner in this initiative. Both the content and format of Melbourne Forum 2020 were inspired, like so many things these days, by the COVID-19 pandemic. Our online format has allowed us to open the Melbourne Forum to the public and also necessitated hosting the forum as a 4-part series. In content, the entire forum is focused on issues of representation in democracies and emergencies, and today's session will look specifically at lawmaking and accountability in the context of emergencies. Our esteemed panelists will explore this theme from the perspective of 5 countries: Papua New Guinea, New Zealand, South Korea, Malaysia, and Singapore. Questions for discussion include the impact of the pandemic on relationships between the executive and the parliament, how practices and procedures of lawmaking bodies during the pandemic were affected, how decisions on spending were made, and if elections were held, how they proceeded. Other notable issues are how the pandemic affected relationships between opposition and ruling parties and coalitions. This came up in most of the case studies. As we often look at parliaments as a key site for representation in government, it is critical to understand how they were able to operate during the pandemic and if they were able to fulfill their key functions of lawmaking, ensuring oversight and accountability in government. In addition to these questions, the background papers prepared for this panel, which are all available on our website, highlight the interconnection between our sessions with the role of courts, as well as issues related to multi-level governance highlighted in these case studies as well. The procedures used for declaring states of emergencies, in line with our first webinar's theme, were also fascinating, with only PNG invoking its constitutional state of emergency procedures. Each panelist, in line with our regular format for the Melbourne Forum, will speak for 5 minutes, and then we will open the floor for question and comment, both from our other Melbourne Forum members, who we invite to use the raise your hand feature in the chat if you'd like to share some of your experiences or ask a question, and also from the members of the public, and for that you can use the Q&A feature in Zoom. I very much look forward to the discussions ahead, and will now introduce our first panelist for today, Dean Knight, who is an Associate Professor, Faculty of Law at the New Zealand Centre for Public Law, the Victoria University of Wellington. He specializes in public and government law with particular emphasis in his work, including judicial review of administrative action, local government, democracy, and constitutional reform. Dean has recently been a visiting fellow at the London School of Economics and Political Science and an international visiting fellow at the Bingham Centre for the Rule of Law at the British Institute of International Comparative Law. With that, I would like to turn it over to Dean to begin the panel discussion for today.
Kia ora koutou, and it's a real pleasure to join in this hui today from Aotearoa, New Zealand. So a little bit of background about New Zealand's response to the pandemic. First, in terms of the public health response, New Zealand we've been pursuing an elimination strategy. That's not eradication, but doing our best to stamp out the number of instances of the virus. So we did have a 7-week lockdown a few months ago, 1,500 cases of the virus and about 24 deaths, but then managed to remain COVID-free in the community for about 100 days until late last month. We had a small, a growing cluster outbreak in Auckland and a short, sharp lockdown again in Auckland, but regionalised this time. So the public health response has been built around the elimination strategy, and the governments are continuing to pursue that. In terms of the legal response, and I thought it might be useful to think about the values which have underpinned the response in New Zealand. And there's 3 that I've drawn out and I've sort of seeded through my paper. And the first one is the idea of legal pragmatism through a sort of a multi-tooled crackdown. Secondly, constitutional fidelity through what I'm describing as regulatory humility. And thirdly, democratic legitimacy through improvisation. And I'll just touch on each of those. In terms of legal pragmatism, I'm speaking there of the way that the lockdown was implemented and the other restrictions were implemented, because they weren't affected through a singular means. We had a very messy network of old and new regulatory tools. So health orders issued by the Director General of Health, the senior health official, based on powers to address infectious diseases from the 1900s, later beefed up to be health orders issued by the Minister of Health under bespoke COVID legislation. Also backed up with some directive powers of constables under civil defence legislation, but also a very heavy emphasis on advice and nudges from a very powerful communication strategy. And especially notable is the vivid alert level framework of 4 alert levels with different conditions and restrictions, which has been especially useful for the community. So that's a mixture of regulatory tools being used, but within that, constitutional fidelity through regulatory humility. And despite emergency settings being triggered, epidemic notice being issued, state of national emergency, all the measures that were implemented were through subordinate instruments. And the consequence of that was that they're all subject to court challenges on legal and rights grounds. And we had an unsuccessful challenge to those orders that were issued recently. And also those orders were ultimately subject to parliamentary oversight and disallowance. Notably, some Henry VIII clause or a Henry VIII clause in epidemic legislation that was available was barely touched. So I'm reading that absence of special protection for emergency measures as very much acceptance that the measures must be rule of law and rights compliant. So the government must meet those expectations on the merits. So preservation of that rights culture, rule of law culture. And that really feeds into the third point, which is democratic legitimacy, because much of the pathways our government's taken have respected the need for the government's response to be legitimate and acceptable to the public. So for some examples that can sort of illustrate that. In terms of the decision-making of the senior health officials, Cabinet wrapped itself around that Director General in making the isolation orders to cloak that technocratic position with the necessary political legitimacy. There was also acknowledgement through the emergency that acute accountability was needed. So while we had some disruption to our formal processes like Parliament, which adjourned for just about a month, there were some innovations. We had the very successful bespoke Epidemic Response Committee for about over a month, a Parliament in miniature, very much exacting accountability on the executive for the decisions they were making. Daily ministerial and official briefings, I don't think we can underestimate their role in rendering account. We also had proactive disclosure of all cabinet papers on a monthly basis. Now that's a relatively recent generic innovation, but one which became acutely important during the emergency. For me, the one weakness in this democratic legitimacy has been the speed of some of the parliamentary lawmaking, both on pandemic and non-pandemic legislation. We had a whoopsie where the wrong bill was passed before anybody noticed, thankfully not a serious one, but also an unwise decision to expedite the passing of a COVID framework legislation in 2 days without consultation, but then with some innovation because that legislation was immediately referred to a select committee for post-enactment review. So just to summarise, all in all, I think the COVID conditions in New Zealand have perhaps provided reasonably favourable conditions for democracy and parliamentary accountability. Short lockdown, limited civic disruption, but I think very strong sense of culture and dynamic that legitimacy is the key to maintain that public cooperation through the emergency and ensure the social licence for those measures. Kia ora, thanks.
Thank you so much, Dean, and thank you for keeping to the time. We really appreciate that. What I really enjoyed about reading your piece was that the relationships maybe didn't change fundamentally, but you had this phrase of the loudness and frequency of executive action that I think is probably relevant in a lot of the case studies we're looking at. With that, I'd like to turn it over to Jeong-In, who's a research professor. She will share with us about Korea, and she leads the Party Democracy Research Department of Party Law Research Center at Korea University in Seoul. She teaches research and rights on constitutional law, fundamental rights, comparative constitutional law, constitutional amendment, democracy, and constitutional education. We're honored to have you with us today, and with that, I'll turn it over to you for your 5 minutes.
Thank you for having me. I am Jeong-In from South Korea. After the first case was reported on 20 January 2020, South Korea had the second largest number of confirmed cases behind China in the early days of the COVID-19 outbreak. Currently, however, South Korea has flattened the curve and is known as one of the countries which effectively responded to the pandemic. From the initial stage, COVID-19 was categorized as the highest level of disease according to the Infectious Disease Control and Prevention Act in Korea, and it was treated as a disaster according to the Act on Disaster and Safety Control. From the experiences of tackling the SARS in 2003 and the MERS in 2015, it was generally recognized that a uniform government-wide response is a crucial key to prevent and confine the spread of infection effectively. The South Korean government took a confinement strategy, in other words, containment strategy from the beginning. In practice, this aimed to identify the infection as early as possible, as quick as possible, and to prevent spread through contact tracing very thoroughly, and to provide cost-free treatment according to the law. When a person tested positive, the central and local governments traces the source of infection using any technology such as mobile GPS, CCTV footage, credit card records. For preventing infection, various kinds of compulsory measures have been taken by the central and local governments according to the Infectious Disease Act. The measures, which are issued in a form of administrative order by the Minister for Health and Welfare, and each head of local governments, are enforced with the help of National Police Agency and local administrative powers. If one violates the measure, they could be punished. One inspiring thing is that South Korea was the first country which held a nationwide election since the pandemic began. Although there were mass infection and community spread in February and March, just a couple of weeks before the election day, so the government enhanced the social distancing strategies. But the election was held as planned under the intensive instructions. For example, ordinary voters had to vote until 5 p.m. and then people under self-quarantine were permitted to vote later from 5 p.m. to 6 p.m. Before the election day, there were overseas voting, shipboard voting, early voting, and even home voting. In other words, post-voting were implemented. Moreover, early voting was largely encouraged, and post-voting was expanded. In terms of the pandemic, the election result was remarkable in two ways. First, voter turnout marked the highest in 28 years, which is 66.2%. Early voter turnout was highest since it was introduced. Secondly, no mass infection caused by the election was reported afterwards. Then, regarding the parliament's role, which is associated with the presidential system in Korea, the balance of power between the legislature and the executive power in South Korea is already uneven. The executive power is strong and concentrated. The ruling party is very subjected to the president institutionally and politically. So the effective parliament oversight and checks and balance on the executive power by the parliament are largely depending on the composition of seats in the parliament. The landslide victory of the ruling party in the recent election makes the function of parliament to scrutinize and to hold the government accountable more obscure. So we may learn from the experience of South Korea as follows. One, declaring the state of emergency was not always necessary. Two, instead, for the necessary measure, there should be parliament legislation which grants the executive large discretion. Three, there should be close cooperation system between central and local governments and between governments and medical experts. Four, if there are proper preparation and public communication, the election that builds the representative organs such as parliament and president needs not be postponed. Last but not least, For maintaining the parliament oversight on the government's audiovisual power, the role of the opposition is crucial, and therefore there should be a well-designed electoral system. Thank you for listening.
Thank you very much for your insights. I think it's very interesting to look at the role of opposition, and it did come up in several of the case studies. So I look forward to exploring that more, hopefully in the Q&A as well. I'll turn it over now to Wilson Tay, who is representing Malaysia today. Wilson is a senior lecturer at Taylor's Law School and Taylor's University in Malaysia. He teaches constitutional law, administrative law, and the legal systems of England and Malaysia. We welcome you, Wilson, and I'll turn it over to you now for your 5 minutes.
All right, thank you very much for inviting me to present at today's session on lawmaking and accountability in responding to COVID-19. Okay, so in the case of Malaysia, we began seeing unusually high rates of infection in the month of February and March, and it really spiked following a gathering, a large public gathering in the capital in early March, okay, on the 1st of March, the weekend of the 1st of March, and then the health crisis basically took off from there. Okay, so the government's response to that essentially came in the form of executive orders, which were called movement control orders. So there was a series of movement control orders, which began on the 16th of March and were invoked under the powers available to the government in the Prevention and Control of Infectious Diseases Act 1988. So I was very struck by the previous presentation also that in Korea, there was no need to proclaim a state of emergency before the drastic control measures were imposed, because that is also what happened in the Malaysian experience. So despite the availability of broad powers to proclaim an emergency or to invoke the national security legislation, these turned out to be unnecessary, because as it happened, the Prevention and Control of Infectious Diseases Act provided the government with ample powers to introduce a series of movement control orders, which, as I said, kicked in on the 16th of March, and under which the government restricted international travel in and out of Malaysia. The government also restricted the opening hours of business premises and progressively tightened restrictions on individual movement in the country. Okay, so violations of the movement control order, such as being out of doors without a valid reason from the hours of 8 p.m. to 7 a.m. in the morning, would be punishable by a compound of 1,000 ringgit in the first instance, and for repeat offenders it could get higher, or for the more egregious offenders it could get higher if they were subsequently prosecuted for offenses under the Act itself. Okay, so essentially what had happened was that the country went into a state of restricted activity for the period from 16 March onwards. And this had an impact as well. I think if you see the paper which I put out, and I mean, I'm not going to rehash the whole thing, but there was a political crisis going on at the same time in Malaysia. And we saw that what had happened was the fall of the previous government at the same time as the COVID crisis was escalating. Okay, so we had a new government in power whose parliamentary majority was initially uncertain. Okay? I mean, at least during the early days of the COVID outbreak. So what we had at the same time was the government legislating through these executive orders to restrict public movement, and also to invoke large sums of public expenditure, or to engage in large-scale public expenditure through a series of economic stimulus packages, okay, known as the the Prihatin and then the Bencana scheme, which initially were cash injections, injections from the public sector to stimulate and galvanize the economy, which had been, of course, severely affected by the restrictions. So, okay, what was going on, and what was perhaps a bit concerning, was that there was a parliamentary session that was supposed to have been held in early March, and because of these movement control orders and the general public health situation, that session had to be postponed. Okay, now that raised a question under the Malaysian Constitution, because under the provisions of Article 55, you cannot have more than 6 months between the last meeting in one session and the subsequent meeting in the next session. Okay, so then what we had was that in May, the government organized a half-day sitting of parliament. Yeah, half-day sitting of parliament at which there was essentially only the royal address and nothing more took place. Even though, as I mentioned, the government's parliamentary majority at that time was uncertain, and there were attempts by the opposition to mount a motion of no confidence. Okay, so the government held that half-day session, and then parliament was adjourned to July. Okay, then of course in June, the public health crisis had relaxed a little. And in July, then Parliament convened again. And by then, the government had cemented its majority. Okay, so what we saw was that as a matter of political accountability, the government was able to kind of suspend parliamentary oversight over the public response to the COVID crisis for the duration of these movement control orders, or at least the early stages of the movement control orders, before we move on to what is now the recovery movement control order, which is essentially a reopening of the country, subject to standard operating procedures, like mask wearing and so on and so forth. Yeah? So, okay, essentially the interesting thing about Malaysia's response was that it was largely executive order based, okay, and we did not have to proclaim a state of emergency or to pass any special legislation. And B, parliamentary scrutiny was momentarily suspended, okay, even though it had significant political consequences, we shall say, yeah, arising out of that temporary suspension of parliamentary scrutiny. Okay, so I think that is the key takeaway from the Malaysian experience. The details and the particulars of that in the paper which I have provided and the organizers have kindly uploaded. Huh? Okay, so I will not take more time than is necessary. Okay, thank you.
Thank you so much, Wilson. I really appreciate the insights. Again, I think there are a lot of interesting parallels with Malaysia and Korea, but also with some of the case studies we looked at in the first session, including Timor-Leste, and hopefully we'll have some comment on Sri Lanka as well, which has experienced a break in parliamentary orders during this period as well. I'd like to turn now to Dr. Bal Kama. He's a lawyer and academic admitted to practice in the Australian Capital Territory and the Supreme Court. He has a Bachelor's of Arts and a Bachelor of Law from the University of Canberra, a graduate diploma of legal practice from the Sydney College of Law, and a PhD in law from the Australian National University. Bal Kama will share his experiences for 5 minutes, and I'll turn it over to you now.
Thank you, Amanda. And thank you for those who have extend the invitation for me to be here and share on Papua New Guinea. I have put up a paper out, and I think there's some figures changes in terms of the COVID case in Papua New Guinea. I've noted 400 cases. The last 2 weeks, it has now increased to 500 now. As a figure of yesterday's 506 cases and 6 deaths. I would like to start off with a sense of comparison to the case of, or the last case that Wilson was talking about in terms of Malaysia. Unlike Malaysia, Papua New Guinea, when it has the first COVID case in March, it declared a state of emergency under the constitution. The first phase of the constitution provides that the executive can go ahead and declare a state of emergency in the first instance, but that only lasts until the parliament meets. And the parliament met 14 days after, and they extend that declaration. But the issue that comes out of, and I think, looking at the timing, I think something which I'd like to speak to is the consequent request and the consequent declaration is taken away from the parliament, and it's captured under the new act passed by parliament, sponsored by the executive, and that's the National Pandemic Act. Essentially, what the act does is that it, in a way, have exactly what Part 10 of the Constitution has in terms of declaring a state of emergency. In that it seeks to achieve the same purpose, but it takes away the parliamentary oversight. So under the Constitution, Parliament has a significant oversight on the state of emergency. And you will see in my paper that I've noted that, especially in terms of using the Parliamentary Emergency Committee. And that's a committee made up of the opposition and the government members. And the executive would have to request an extension or a continual orders in terms of state of emergency through that committee. But what the Act does is that it takes that away. And so the executive can now issue orders and therefore public health emergency orders under the Pandemic Act without the constant oversight, without the constant sense of review by the committee and therefore by the Parliament as well. The opposition leader is now challenging this legislation. And for those who may not be aware, the opposition leader in Papua New Guinea has standing to seek judicial review. So what that means is that if he cannot defeat or if he cannot oppose successfully a legislation in Parliament, and if he deems that this legislation is of national significance, then he can always go to the court. Also, while the opposition is seeking that, the local governments, so far they have been cooperative with the national government, but there is also indications that if the national, if the orders under the Act is the continual orders under the Act is something that they're not happy with, then they've indicated to also go to the Supreme Court. And again, the local level governments in Papua New Guinea have standing guaranteed by the Constitution to seek any legislation or seek the court's review on any legislation. And that is some of the accountability frameworks around legislation on public health as it is. The other thing, I guess, to point out is that the Supreme Court has a very strong sense of protection over Parliament. It has, on many occasions, condemned Parliament acting as a mere rubber stamp, and it has used these words quite often when it comes to parliamentary oversight being skipped or parliamentary oversight not taking its full course. So it'll be interesting, I guess, to see how the current challenge in terms of the Pandemic Act in the Supreme Court goes. I cannot comment on the merits of it, but I've made some comment in my paper. I guess that's, I'm sure my time's up on it, but happy to answer any questions. Sorry, just before I finish, you can also see from my paper that there is tension, some ongoing tension between the local level governments and the national government. And with Papua New Guinea having the context of about 6,000 groups, 830 languages, this idea of centralized and decentralized government is a very contentious point. And the positive of this emergency, of COVID-19, I suppose, is it's allowing the national government to work closely with the local governments. And I think that's probably not a good, I guess, positive in terms of, we don't want to talk about COVID-19 in terms of positives, but for Papua New Guinea, the decentralization framework is possibly helped with that. Thank you.
Thank you so much for your insights. I was also curious, I'm glad you made that final point about the relationships, because you said at the end that they were better coordinated, but there are some pretty strong statements in your piece from different governors against the national action. So I'd be curious to hear more about that. I also really like that you spoke about the drafter's intent in shaping the state of emergency procedure, which was very interesting for our discussions. Last but not least, I'd like to turn to Jaclyn Neo, who will be sharing experiences from Singapore today. Jaclyn is an associate professor of law at the National University of Singapore and the director of the NUS Center for Asian Legal Studies. Her work forefronts Asian jurisdictions in comparative constitutional law and has been cited by the courts in Singapore and the Supreme Court of India as well. Thank you so much, Jaclyn. With that, I'll turn it over to you.
Thank you, Amanda. Thank you to Cheryl and Anna for convening this forum, and also to Charmaine, who has brilliantly answered all my questions on the forum and so on. So I'm going to speak from the perspective of Singapore, but hopefully sort of draw out some of the possibly more general points for comparative purposes. I have been told to assume that everyone will have read the papers, so I will not go into too much detail except to make the points that I wish to highlight. I'll make 3 points in this presentation and draw from the paper. The first is that despite the sort of global constitutional, comparative constitutional context that we find ourselves in today, it would seem that the political structures in which our various systems find themselves in remain highly relevant. The second point I want to sort of point to is at least in the context of Singapore and perhaps in the political structure that we find ourselves in, is the limits of legal constitutionalism in an age of COVID-19, in an age of sort of pandemic. And thirdly is to emphasize that the particular context that Singapore has, which is often referred to sometimes as authoritarian, but my preferred term is dominant party state, you will find that even in such a context, we do see critical elements of accountability, perhaps not through judicial review as is sometimes assumed. So those are the 3 points that I'll go through drawing from my paper. On the first, which is the persistence relevance of political structure. I'm sort of joined here by colleagues from Malaysia and New Zealand, where we've drawn our political structures from the Westminster parliamentary system, which has in it a very strong commitment, I would say, to Parliament as the most democratic branch in government. Even though in a country like Singapore and also Malaysia, we have a constitution that declares itself to be supreme. But the structure that we see is this fusion between the legislature and the executive. And that fusion, having the executive drawn from the legislature, creates a very close relationship whereby one does not necessarily see Parliament playing as strong a role as it could play in controlling or having oversight over executive action. And oftentimes what we see is that legislature is very happy to grant broad powers to the executive to address rapid type situations like COVID-19. And this is what we see in Singapore. We have, of course, a dominant party in Parliament, as I mentioned. Initially, a lot of the responses to COVID-19 were premised upon 2 existing statutes. But when it was clear that those statutes were no longer sufficient, what happened was that Parliament quickly passed the COVID-19 Temporary Provisions Act. It was fast-tracked so fast that they passed it within a day. That 3 readings, first reading, second reading, third reading, and everything was done within a day. This is unprecedented even by Singapore standards, okay? What is also critical about this act is that it actually delegates significant power to the Ministry of Health to promulgate regulations. And these regulations were in fact key to what we call the circuit breaker. Essentially a lockdown, but we don't call it a lockdown, we call it a circuit breaker. The circuit breaker entails the restriction of movement outside one's ordinary place of residence. It entails the prohibition of gatherings between persons living outside one's household, as well as creating of certain offenses in violation of social distancing requirements. In addition to that, Parliament also passed 4 budgets to deal with the economic fallout from COVID-19, and this actually entailed a drawdown of up to 93 billion to deal with COVID-19. So you see that fusion between the executive and the legislature, creating the conditions for a very fast and very prompt response, not just to the health measures, but in terms of economic measures as well. Now, going to my second point very quickly is the sort of limits of legal constitutionalism in this context. The Constitution barely was barely mentioned during all of this, except for one aspect, which was an amendment to the Constitution to allow Parliament to meet at different places simultaneously. So you see here that I think Bao was talking about how you can go to courts. There was no such sort of, there was no, I suppose, desire for courts to be involved in this current situation, in addressing some of these COVID-19 measures. Now, the last point I would make, which I wanted, is the question of accountability within the dominant party context. Now, I'm out of time, Amanda, I'm just going to end on this. Now, I think it is important to recognize that a dominant party state doesn't mean that there is no accountability. It is just that the accountability comes through different avenues. And in this current pandemic, what we see is that accountability coming through elections. The party that was in power has been in power since 1965. Obviously, they won the elections. But what was crucial is that they won the elections at with a lower popular vote than they themselves expected. They won it at 61.2%. I think they were trying to do better. And at the same time, what happens was that the opposition actually made gains in terms of seats in parliament. Well, 10 seats out of 89, that's not a lot, but in Singapore's context, that is actually the most number of seats an opposition party has ever gotten in parliament. And it was so significant that the Prime Minister actually offered an official position as leader of the opposition to the leader of the opposition party that got the 10 seats. Now, there was a bit of soul searching after that, where the Prime Minister said, well, the Prime Minister-elect that said that it was clear that COVID-19 played a significant role and that the results reflect the pain and uncertainty that Singaporeans feel in this crisis, the loss of income, the anxiety about jobs, and the disruption caused by the circuit breaker and safe distancing restrictions. And so there were, on this point, I wanted to say that even in a dominant party context where the advantage is that the party can respond very rapidly to these, to an issue such as, to a context such as COVID-19, you still do see public opinion as well as elections coming in play to constrain these types of to constrain the government in dominant party context. And so just because you're dominant doesn't mean that you're not accountable. Thank you.
Thank you so much, Jaclyn. That was a really great point to end on. And I think in your piece, you ended also on a pretty hopeful note that maybe this would point towards more pluralistic politics in general for Singapore, which I think would be great. I also think it's a good note to end the discussion on, to think about what positive innovations have come out of this. I think all the papers showed that there have been innovations and processes and procedures that would be really interesting to look at, and how those might be continued over time once the pandemic is over. To all our guests who are joining us online, I know that you might not be familiar. We have quite a large group of our Melbourne Forum members online today. And before we open the floor to general questions, I wanted to invite them to, if they feel comfortable, turn their video on, and also to maybe share some of their country experiences that are also relevant to our discussion today on lawmaking. I think Dinesha volunteered to be the first and share a little bit about Sri Lanka, which we have a lot to learn from as well. But I don't know if Ramdas or Ricardo want to weigh in on their countries as well. But I'll start by turning it over to Dinesha, and then we'll open the floor to general questions.
Thank you, Amanda. I want to first thank the panelists of today's webinar for sharing with us their insights and analysis. It was actually very helpful in developing a better comparative perspective on the developments in Sri Lanka during this time. So I just briefly explain what happened to Sri Lanka's parliament during this time, and that might help us to try and understand the developments in the region a little bit more. So Sri Lanka's parliament was dissolved 6 months ahead of its term on the 2nd of March, and this is provided for by the constitution. But the constitution also explicitly provides that the new parliament ought to be convened within 3 months of such dissolution. Sri Lanka has an independent elections commission. So the election was declared to be held on the 25th of April. After the nominations were accepted, the Elections Commission postponed the elections. And this, of course, led to controversy. The matter was taken to court. The court dismissed the applications without providing reasons for the same. And subsequently, the Elections Commission declared the date of election as the 5th of August, which was well past the constitutionally mandated period of 3 months. Interestingly, we had a 76% voter turnout, and the new parliament met on the 20th of August. I was struck by Jaclyn's point about the constitution and its relevance or irrelevance. It almost seemed as if at this point, the constitutionally mandated period for the parliament to reconvene was ignored. And then, of course, it brought with it the other implications of approval for public expenditure, the fact that Sri Lanka responded to the pandemic without using the option of declaring a state of emergency. We had an extended period of curfew in Sri Lanka, the legality of which and the constitutionality of which still remains disputed. So there were really important constitutional questions that came up, which did not seem to gain the traction that it ought to have gained in the public discourse on this matter, and one would say was perhaps significantly overshadowed by the fact that the pandemic response was effective. So I'll just leave it at that for the moment. Thank you, Amanda.
Thank you so much. I see we also have Rohan. I don't know if Rohan would like to make any comments on Sri Lanka's situation before.
Well, thank you. If I could just add to what Dinesha said, in addition, it was quite clear that the government did not want to declare a state of emergency because the government knew that if a state of emergency was declared, that automatically some checks and balances would kick in, such as the reconvening of the dissolved parliament. There was also a piece of legislation that the government could have used, the Disaster Management Act, which was introduced at the time of the tsunami in 2004, which the government, again, deliberately chose not to use. It would have created a fairly effective mechanism, but it would have involved the engagement of the leader of the opposition and various other mechanisms. So the bottom line, I just want to sort of underline what Dinesha said, was that the government wanted untrammeled power, unrestricted power, so much so that they did not even declare a state of emergency or use existing legislation, and they just did what they wanted to do. And even today, there are questions about the legality of what they did. And the problem is that public opinion in Sri Lanka does not seem to care about that at all. And that's the real depressing point. So I'd just like to add that to what Dinesha said.
Thank you. Yes, a bit depressing, but also interesting to think about the elections in Sri Lanka that happened in the same COVID period.
I actually had just a question generally for the the speakers. It was really interesting presentations. I was just curious. We heard a little bit about this in the Papua New Guinea case, and I'd be interested in hearing about it more there and in other cases as well, about how what role the judiciary sort of at the Supreme Courts in these countries played in sort of managing or sort of holding, the way in which power would move away from, or did move away from the legislature to the executive during the period? How would the courts and the judiciary sort of intervene in sort of that legislation and executive relationship during COVID, if it did at all in these countries?
Thank you. Yes, Cheryl, we'll take a couple questions and then.
Thank you for the presentations, everyone. They were absolutely fascinating and throw up a very wide range of questions. But I'd like to pursue an issue that Amanda actually raised in the course of chairing, and that's the question of the role of the opposition. That comes up in 2 or 3 of the presentations, sometimes quite starkly. Certainly in New Zealand, also in Papua New Guinea, also to an extent in South Korea. And it chimes with something I've been thinking about anyway. What is the most effective role that an opposition can play? Should it primarily present itself as a positive force, as an alternative government? Should it conduct the business of spoiler in order to win government for its own purposes? And in particular, how should this work out in emergency conditions? So I'd be very interested to hear from, say, Dean and Bal, perhaps, about the different roles that the opposition play. I mean, Dean, in New Zealand, the idea that the opposition leader chaired that accountability committee is, to the rest of us, I think, absolutely fascinating. How did that work? Is there something distinctive about the New Zealand political culture that made that a possibility? Whereas Bal, I get the impression that it was quite different in the PNG context. So thank you.
Okay, do we have any other questions in the first round? Maybe I'll take one more from Ramdas.
Hi. My question has to do with that paper from South Korea, which referred to omni-surveillance, which is a new tool. I mean, AI data gathered from telephones, tracking individuals using these data are probably new tools in surveillance activities, which raises privacy issues, constitutional issues. To the best of my knowledge, I think Singapore and possibly even Malaysia have the capability of doing similar things. My own experience in India, or based on what I know, is they've used it, they have developed an app to do a lot of tracking, but they really haven't used it effectively except in 1 or 2 locations. So I'd like to have a discussion or answer to how omni-surveillance is now becoming an issue during a pandemic, given all the constitutional and legal issues involved.
Thank you so much. It's a very interesting question. I think we'll take one more in this round from Dinesha, and then we'll have some questions that we've received from the audience.
Thanks, Amanda. 2 fairly narrow questions, actually. So one is to Wilson about the Control of Infectious Diseases Act, which you said was passed in 1988. I was wondering about the context in which this act was passed. And the other question was to Bal about the provision for declaring a state of emergency for infectious disease. Again, whether there was a specific context in which infectious diseases were included as a grounds on which an emergency could be declared. I'm only asking this because when this question of whether a state of emergency should be declared in Sri Lanka came up, the question was whether this came under public health an order or not. So I was wondering about the history of this act in Malaysia, but also very specifically the grounds for state of emergency in PNG. Thank you.
Thank you so much. Would you, the panelists, like me to repeat any of the questions, or otherwise maybe we can start in reverse by answering Dinesha's, since they were relatively narrow, and then give everyone a chance to respond to some of the other questions. Bal, I believe you're on mute if you're trying to speak.
Me, is it? I'm okay. Yeah, well, okay. So I think Dinesha's first question was to me. So yeah, thanks a lot. I will just presume that I'm supposed to answer. So yeah, okay. Well, with regard to the Prevention and Control of Infectious Diseases Act, yeah, I think the natural question is when looking at how the Act was deployed in the COVID emergency would be the context in which such broad powers were granted to the executive. But I think as far as we know, I think in the late 80s, there was not this kind of intention to actually convert this piece of legislation into something with which the executive could make such broad discretionary measures. Because if we look at what happened in those decades, we had pretty tough internal security legislation, which would have more than sufficed to deal with this kind of internal threats if ever such a need arose. Now, of course, those internal security legislations were replaced earlier in the last decade. Now, the public health crises that we had in Malaysia in the 80s and the 90s were the AIDS, HIV concerns. I mean, I think that was a global issue at that time. But other than that, it was largely local diseases like dengue and encephalitis, this kind of diseases. So I believe what had happened was that it is part of a general trend or a general tendency for the legislature to grant powers to the executive in relatively broad terms. And of course, as I highlighted in the paper as well, that raises a concern with the way in which laws are framed in this country, in which the executive seems to wield a very large margin of discretion vis-a-vis the other two branches of government. So we have only recently been seeing the judiciary pushing back after a long period of time with things like the basic structure doctrine and increased judicial oversight of administrative action. But with regard to the legislature, it is a recognized issue that the legislative oversight over the executive still leaves much to be desired. And that was a large part of the new government's platform, to have more parliamentary scrutiny committees, to reform parliament to be more independent of the executive. But this did not come to fruition before the new government was lost its parliamentary majority, as it happened. So yeah, I do not think that there was anything, to answer the question more directly, I do not think that there was anything in particular in the context in 1988 which suggested that the government foresaw these circumstances in particular, but rather that it was part of a very general trend which presented itself fortuitously to the administration when the COVID crisis arose. Yeah, so thank you.
Thank you. Bal, would you like to answer Dinesh's question? And
Sure. Sure. Yeah, thank you for that question. Papua New Guinea under Section 226 of the Constitution has a set of events that can trigger a state of emergency. Pandemic is one of them, an infectious disease, to be more exact, and things like having an earthquake or having a bushfire, anything that will amount to affecting a huge proportion of population, and anything that will amount to, well, as a result of that event, allow the state to restrict rights and movements to a larger extent, then it falls back onto the Constitution. And I've pointed out, I guess, understanding the context of others who have spoken about the similar kind of events being regulated by an act and not by a constitution. Papua New Guinea has a very sensitive approach when it comes to making the constitution. It was quite sensitive to ensuring that the executive is as limited in its action as possible. Part of the reason is because of Papua New Guinea's experience under the Australian Constitution. The Australian government at the time, when they were ruling Papua New Guinea, some of the actions Papua New Guineans weren't quite happy as to how the executive went about ruling. So they said, look, in our new constitution, we have to ensure that the executive is as tight as possible. Now that's another topic, so I should not jump into that space, but that's probably summing up that you will find Papua New Guinea is more broad in capturing anything that will trample upon people's rights in a large proportion. It has to be captured by the Constitution. Not only that, but it again provides mechanisms to really restrict and provide close oversight of what the executive does. And so that issue came about in terms of the National Pandemic Act, which is now the subject of a Supreme Court case. I hope I've kind of broadly touched onto that question. If you mind, Amanda, I can proceed to answering the other questions, if that's okay.
Sorry, I'm on mute. Of course, yes, you can do that.
Perfect. So if I can take Sarah's question about the role of the opposition, I think it's a very, very important question. Opposition in Papua New Guinea is very active and has always been active in terms of, mainly because the political context of Papua New Guinea is so intense that you got to be on your feet every time, keeping the government accountable. So the opposition is naturally active, and I think this kind of time provides more ammunition for that. My concern, though, is that, and I've expressed in other forums and papers, is not, and I hope the opposition won't be to a point where it will create division within the community. Because ultimately, as I pointed out in the paper, is we need a strong sense of unity for the country, and a very fragmented country like Papua New Guinea with lots of groups and languages, and it is easy to become fragmented and therefore undermine effective enforcement of public health measures if the opposition is taking a route that is entirely political. So that is my caution, but otherwise, so far the opposition has shown to be quite firm in its position in terms of holding the government to account. And not only opposition, there are other, groups out there in terms of the local level governments and their governors, for instance, are quite vocal as well. The other thing in terms of, and final thing on the opposition, is that because it has standing, it has this guarantee standing in the constitution. So the government is conscious that whatever laws that it passes, they will always end up at the Supreme Court if it doesn't get through the parliament in terms of the opposition. So that is in and of itself is an inbuilt oversight on the actions of the government, that there is that Supreme Court forum which their actions can be subject to. Coming back to the question that Yasa raised, and also I've got another person who raised a question on the courts, the role of the courts. PNG courts are quite vocal on what the parliament should do, and so while there hasn't been any case in terms of reviewing what the executive has come up with, I am mindful that this case at the Supreme Court will get a strong interest from the judges, if it is found to be wanting, of course. Apart from that, the courts have been dishing out COVID-19 penalties, not quite proactively, but they've ruled on some of the matters. In fact, one of the Australian, some of you might be aware, there was a drug smuggling in Papua New Guinea last month by an Australian pilot, and he got caught. And one of the charges that he was charged with was for breaching COVID-19 restriction. And so the court has to penalize him, and he paid about $1,200 as a penalty. I don't think that's a good penalty, but that's I think the case that the court is working on. Finally, there's a question raised about this Supreme Court case currently going on with the opposition. When will the court respond? The court's dealing with many other cases, many other pressing national interest case at the moment. So I don't think we will have immediate answer on that front. Another thing is that the state of emergency has passed, so the courts probably might not see this as a priority case at this stage. The other thing courts tend to keep in mind in Papua New Guinea is to not quickly rule on highly contentious matters. they have some delay tactics to ensure that everything calms down before they give judgment. So I think all these factors will be playing into when the courts will decide on this case. Thank you.
Thank you very much. Just as a reminder, we have the question from Yasser on the role of the courts and particularly in monitoring the relationship between legislative and executive branches of government and emergencies. And a question from Ramdas that is also general on issues of surveillance and privacy in the context of tracking and other responses to COVID-19. So those are directed towards everyone. Before you start though, maybe Dean can weigh in on an answer to Cheryl's question specifically on the opposition, and then we can turn it over to the general panel.
Thank you. Really interesting question. I think two dimensions to it. First, the role of the opposition in the Epidemic Response Committee and what that entailed. And then I guess the question of tone, you know, whether to play the spoiler or the negative role, or whether to be constructive. And on the first, it was the Epidemic Response Committee, our Parliament in miniature for about 6 weeks, was fascinating, because not only was it the opposition leader chairing it, it was an opposition majority on the committee, so able to control agenda setting and so forth. And while we're locked down, it was the only show in town apart from the PM's briefing at 1 o'clock. So 3 days a week for 3 hours a week, we were glued to the Parliament channel, watching it as experts, people affected were being interrogated, ministers, officials. And so the only interesting thing was the only minister not called that might have been called was the Prime Minister. She was never called to appear before that committee, but the Health Minister and other ministers, finance ministers were. So I think it was a very brave government to agree through our business committee processes to set that up. But I think it shows that commitment, I guess, to contested politics and democracy, because it's effectively handing over the podium to your biggest opponent. But the question about that is, you know, how did the opposition come out of that? Well, I'll say the committee itself for the first 4 weeks was really constructive. It was kind of a model in parliamentary democracy, accountability, very constructive. We were sitting and nodding. And then after about 4 weeks of that, the politics came in. They went on a tangent about whether they could get access to the Attorney General's legal advice on the legality and so forth. And then it kind of disintegrated, and it became less sort of non-partisan and much more politicized, and then eventually got rolled into the wrapped up once Parliament itself resumed. But negative tone, positive tone. Well, since the lockdown, we've lost 2 opposition leaders and 1 opposition spokesperson of health. We're on to a 3rd opposition leader, and the opposition party, lead party, has dropped from about 45% in the polls to lower than 30%. So I think they probably got it wrong. Well, in the sense that I think there has been concern that they've spoiled too much, they've been too negative, and people wanted constructive accountability. How much, I'm not sure that the opposition could ever have met that, because on the other side of the calculus, you have a very charismatic Prime Minister who is building trust and confidence through a whole sophisticated and authentic narrative about what it means to be in the pandemic and to work as a team of 5 million. So just to give you an indication, the support for the lockdown, our first national lockdown, 92% in support. It was built on the idea of a nation together being led and earn trust. So I think it was always going to be hard for the opposition to try and navigate that delicate equilibrium about, you know, how much do they prod and probe, how much are they constructive, do they shut up shop and just, you know, let it run, because, you know, it's just really, really hard. And I think they're still struggling with that as we go into the election, in terms of how much do they press on ongoing concerns about quarantine breaches and testing problems and things like that. How much do they say we could do a better job? They're just not getting any traction politically on that. But, you know, I think it was that they were on a hiding to nothing anyway.
If I may,
Yes, please.
Sorry, can I just add something to what Dean was noted about having a leader, I guess, who's kind of leading the country and having everyone to be part of that course. I think in terms of Papua New Guinea and the opposition. What we've seen in other countries is some of the leaders in the government are not allowing the space for the opposition to become a voice of reason. Whereas I think for Papua New Guinea's case, it has previously it has had governments that suppress the opposition. But with the current government, the current prime minister is really coming out and really wanting the opposition to have a voice. So I think there is that sense of encouragement from the prime minister that, hey, you know, you can have a similar platform and please go ahead and raise the concerns that you want to. So I think that's that personality shift in terms of the leaders behind and the government and the opposition, and especially the government who have an influence on the speaker, who can give space for the opposition to, you know, I guess, participate in parliament. Previously, speakers are quite suppressive of the opposition, but with this government and the encouragement that we see from the PM himself, the opposition is coming out, being more, much more vocal. So I think that's something to take away as well, in that the personality in power can dictate the extent to which the opposition participate in holding the government accountable.
If I may, I think that this question of the opposition, I agree very much with what Dean said, which is that this is one of those situations whereby opposition members generally have to be very careful in order not to be seen as being sort of obstructive to necessary measures to deal with the health crisis, as well as the economic crisis, right? So we do see some of this rhetoric coming out in the United States, for instance, whereby, you know, both sides are blaming the other for the crisis because, and one of the criticism is that you are being obstructive. You don't care about the people and so on. So I think that in a situation such as the one that we find ourselves in right now, there's always this sort of balance that the opposition members always, you know, have to navigate, which is you want to be seen to be holding government accountable. At the same time, you don't want to be seen to be an obstacle to controlling and improving the economic situation. So I think that that is something that has to be borne in mind in terms of what the opposition can do. And to some extent, if I may sort of go back to the Singapore context, which is where we have a very limited opposition, and yet an opposition that does play an outsized role in comparison to the numbers that they have in Parliament, and that comes from the ability to actually harness the power of social media. And we see this in the campaigning period for the elections as well, whereby the main opposition party in Singapore, the Workers' Party, had, I would say, a near perfect social media campaign. They put out these really well-styled videos that went viral. People were sharing them, whether or not you were an opposition supporter or not. And they put out these messages, right? They were able to use social media and the context of the COVID-19 restrictions, which meant that ground sort of campaigning was very much limited. They used that to their advantage to reach a wider scope of people, a wider range of people, and to show that they cared, that they were the ones who will fight for the little person. They were the ones who really understood the economic impact of COVID-19 and so on. So I think that the measures, the sort of restrictions that we find ourselves in, and the very fact that we are using this as an opportunity to also connect through Zoom, for instance, shows that we will see some shifts in how power is aligned and how communication is being sort of being used to advance certain political interests. I mean, when Dean was talking about the Prime Minister, obviously many of her videos went viral. I've seen so many of them, including the one where she did 100 things that we did in like 5 minutes or something. That was brilliant, right? So it does show that we have, I think, going forward, if this continues, even not to the same extent, political power will have to be, we will need to rethink how accountability is being ensured in light of social media.
Thank you so much. I think these kind of exchanges are really the value of the Melbourne Forum. So it's nice to have them going on, and I don't want to cut off the questions, but does anyone else want to respond to the first round of questions before we move on in terms of the role of courts or the issues of surveillance and privacy? Is there anyone? Yes, please, Jeong.
Regarding the surveillance thing, for the information, more than 90% of people use smartphone in Korea, and they are very active in accessing to the public information, and they are very aggressively sharing their informations with each other, and they have also strong awareness of rights, such as privacy. The government use a comprehensive and thorough tracing tool to screen and identify the infection. For example, any travelers from outside should install an application on their smartphone by which the government manages their situation, whereabouts, or self-isolation during their compulsory quarantine weeks. The public servants call them several times a day, and the quarantined people should answer to the alarm from the app. Another case is that a pastor who had kept holding services at his church against the government notice, even though the government requested all churches not to congregate, eventually held a massive rally on mid of August at the center of Seoul. He previously reported and filed the court that the rally will not be a big size, but contrary to that, more than 10,000 people from all parts of the country gathered, and it eventually exacerbated the spread of virus. The government and COVID-19 control center, and as well as the ordinary people, were so frightened and frustrated. So the government seriously worried about the second wave coming and raised the alert level from 2 to 2.5. Actually, level 3 is like a lockdown, but the government was concerned about economic consequences and the people's acceptability of such severe restrictions. So instead of moving to directly level 3, the government just tightened restriction on social distancing. And simultaneously, the government, using mobile phone GPS tracing, identified all the people who stayed at the rally area, regardless of their involvement in the rally, and called every single person by one to request to take a test. In this way, more than 10,000 people received a call. As a result, fortunately, there was no second wave in Korea. It demonstrates that such comprehensive and thorough tracing was very effective. But as we all aware that it is very worrying thing that such a thorough contract tracing system can infringe our basic rights. Yeah, and we all worry about any such a situation will be a new normal or any convention to our daily life in the time of post-corona. Although citizens recognize it's problematic, it's very problematic in a perspective of constitutional law and in legal perspective. Just for now, but we are enduring it with an expectation that it will not be it will be just temporarily applied. So there's not yet any case filed to court yet, but I think after the highest of this time, there should be a review of such measure or legislation, and the court. I assume there could be certain kind of issues will be raised in the later. Thank you.
Thank you very much. Dean has volunteered to take the question on courts, so I'll turn it over to him.
Yeah, I think I should address it because New Zealand's had a reasonably high-profile legal challenge about to the lockdown measures recently. But actually, for my narrative, the interesting thing is the absence of challenge and the lack of legal accountability, or the fact that people weren't rushing off to court to challenge the lockdown. And just to explain that, the legal challenge to the lockdown that resulted was not a sort of a front-footed challenge to the suppression of mobility rights and so forth. It was a very technical challenge, if I can put it like that, about whether the old infectious diseases powers from the 1900 could be used by the Director General to isolate everybody in the country, or whether it should be used on a case-by-case basis. And if it couldn't, that would have left the government needing to go back to Parliament to get an express power, as they actually did after about 4 weeks anyways. So the case actually happened once the new improved legislation had been in place, so it became a bit historic and moot. And also, and the court said that the power could be used on a universal basis, and made some comments commenting that the restrictions were reasonable, proportioned and justified anyway, even though it wasn't actually contested in court on that basis. But the area where the government lost was in relation to the first 9 days, where there was an allegation that the statements to stay at home weren't backed up by the law, because there wasn't an order formally requiring people to isolate at that point in time. So the allegation was legislation from the podium, if you like. And the government did lose on that front on the basis that the commands or the urgings of stay at home had a degree of normative force, which was interpreted by people as a requirement, therefore affecting their mobility rights in the Bill of Rights. But the problem was that the restriction wasn't prescribed by law in terms of the provision dealing with justified limits. So again, a little bit technical, because the court said, well, the government could have always, executive government could always have done a formal order anyway. So we're just going to say it's not prescribed by law and make a declaration and just leave it there. So again, we have the courts being used, but in a very, very narrow sense about technical reasons, about tools. And to be quite honest, there's quite a lot of adverse public reaction to the case being brought. So it was actually, many of us were mounting a defense of the ability of people to seek these questions, resolution of these questions in the court. But what we didn't have the rush of litigation, say, that was seen in Germany, I understand, where there was much more rights-based challenges. So for me, something about the legal culture there and a commitment in New Zealand to resolve it through the democratic and political avenues rather than the legal avenues.
Yes, please, Val, comment. Do you want to comment?
Yes, just on the courts, just something to point out in terms of the Papua New Guinea Constitution. Section 57 provides for the courts to voluntarily bring the executive to account for human rights violation. So that is I guess, the last thing that court can do. Court can do on their own without any formal complaint being put up, without any case being brought forward. That's the last, I guess, sort of resort that the courts can step in if agencies or if people who are affected by human rights violations are unable to bring, and if the judges determine that the violations are to an extreme that warrant judicial intervention, there is a action of last resort in Section 57 allowing the judiciary to step in. And they've been used that, they have used that in various cases. And if you have a chance to visit my PhD thesis, I've discussed a few of the cases in there, and you will see it's a very, very exciting power. If you are into this kind of judicial liberalism, but if you are more judicial, I guess, non-action, then perhaps that might be not be an exciting thing. Something to note on that front is the Manus Island refugee case. As you'll understand, the Australian PNG agreement. The case that triggered the ultimate dismissal and the overturn at the Supreme Court that the arrangement is unconstitutional. The case that triggered that was launched on Section 57. A national court judge saw violations at Manus Island, and then he voluntarily invoked Section 57, and that started off that chain that ultimately resulted in the agreement being ruled as unconstitutional. So it is a very significant power that judges have in reserve in case anything happens. So that's probably something for Yasa to think about.
Okay, great. Thank you so much. I think we'll turn to, we have one more question, I believe, from our Melbourne Forum participants, and then we'll turn to the public questions. Kimana, if you'd like to ask your question.
Sure. Thank you so much, Amanda, and thank you for the panelists for great presentations and great papers. I realize that all cases are relatively centralized systems of government, whether unitary or federal states in the case of Malaysia, and also executive-centered responses. And I was really struck by the case of Papua New Guinea and Val's comments that there was much better coordination, but then also some tension with some of the regions. And I wondered in the other cases whether there has been this tension between local governments, maybe also regional governments, and the national government taking these measures to cope with COVID, but also looking into the future, whether there are any movements at the local or the regional level to amend maybe the constitution or legislative frameworks to deal with such global pandemics or other natural disasters at the national level, sort of to decentralize the way that they've dealt with these crises. Thank you so much.
Great, thank you so much for your question. Unfortunately, we only have 5 minutes left, which is not a lot of time, so I will maybe end it here. I know we got a couple of very interesting questions from the public audience, and we will try to answer those over time on our website, where you can also read the background papers and register for our next 2 events, which are still coming up as part of Melbourne Forum 2020. But for now, would anyone like to respond to Kimana's question and also any concluding remarks before we end the day? Yes, maybe Jeong and then Wilson, if that's okay.
Sorry, it's not associated with the previous question, but it is associated with the judicial involvement in time of crisis. Judicial involvement during the pandemic is very critical to control the power and to decide on the constitutionality or legality of such measures to protect the rights. But post-decision, after the pandemic or after the crisis, the post-decision or constitutionality of certain measures is also important and is also workable in terms of accountability. For example, the current Korean government had started with an early presidential election in 2017, which was a result of the former president impeachment. One of the claims presented to Constitutional Court to impeach her was that she would completely failed to respond to ferry disaster and neglected her duty to save the lives in 2014. Although the Constitutional Court did not accept the arguments, but she was impeached finally, and criminal proceedings are still pending. And it is, but it is undeniably shared that former government totally lost public trust from the disaster response, and the government should be asked to take charge of it. Moreover, current President Moon Jae-in of South Korea then was a leader of the opposition party, had a hunger strike for 10 days to support the victims of the accident. So as a consequence, a responsible dealing with the disaster and the constitutional measures and the protection of people's lives are the decisive for the government and president's law. It is widely shared in Korea. So current government has started with its office on this premise and now operating its role desperately. So I'd like to say that the judicial involvement or review on certain measures which was imposed during the pandemic by the executive power could be also scrutinized afterwards. It is also a critical measure to control even it is not timely, or it is it could be late, but it could save the certain constitutional values, or it could ask the accountability of the executive power afterwards. Thank you.
Yeah, I just wanted to respond to that interesting question, I think, on local government and the responses. And I just thought that, I mean, what happened in Malaysia is that because we had a federation, we are a federation of, well, 13 states. And so when the movement control order was first relaxed in May, to have a conditional movement control order, there were some states, you know, because all this was coordinated at federal level, all the control orders were coordinated at federal level. So there were some states that wanted to push back regarding this relaxation of the control orders. And, you know, they wanted to extend the period of restrictions invariably in their states rather than to reopen early. You see? So I think maybe that is instructive in the sense that how executives respond to public crises of this kind is sort of instinctively to try and, you know, to try and continue to exercise as much power as they can, you know. But then essentially what happened was that there were states that wanted to, you know, continue with the more restrictive, you know, control orders, notably Penang and Sarawak, okay? So we did see this kind of thing happening. I'm not sure whether it is because of the federal structure of the country or whether it could also happen in a country with a unitary structure. But yeah, that is essentially what happened. But then that was counterbalanced by the fact that most of the enforcement agencies actually responsible for enforcing the control order are actually federal agencies. So therefore, when the federal authorities decided that the control orders were to be relaxed, even though some states wanted to prolong their control orders, they invariably had to give way. Yeah, so I mean, it is possible in a multi-level governance system for this kind of asymmetry in the response to the control order as well as its relaxation. But I also thought there was a very interesting open question regarding the public response to the tendency of the executive to spend first and get authorization later. And I just thought to say that, I mean, this is not a particularly COVID-specific phenomenon. I mean, if you look at for example, government's response to the subprime crisis or a purely economic crisis, it does happen as well that governments run out of money during the budget cycle and then they come back with supplementary bills, supplementary finance acts, and things like that. So just building also on what Jaclyn mentioned just now about the necessity that opposition and check and balance bodies must be wary of not being seen as obstructionists in nature, because this COVID crisis actually did have a very significant human impact. And we are talking about many thousands of people who have actually lost their jobs, many thousands of people who actually really need government help. And if any party is to be seen as obstructing the necessary measures to deliver relief to these people, I think that the cost will be very heavy and the backlash will be very heavy. So whether they call it accountability or, you know, seeking to hold anyone to account, I think the response has to be mindful of that, because the open question was about what's the role of opposition and, you know, civil society to that. And I think, of course, scrutiny is essential, but that has to first bear in mind the need that people are really suffering as a result of this. People have lost their jobs because of this. International travel has been suspended because of this. And I think that any kind of scrutiny must be sensitive to that aspect as well. Yeah, so I think that it is not something very unusual for governments to have to spend as a result of certain contingencies ahead of parliamentary authorization. It is the quantum that is spent, the way in which it is spent, and whether there is any subsequent accountability that I think are the more important factors that we should focus on. So that's all that I would say. Thanks.
Thank you so much, Wilson, for reaching into the questions we didn't get to ask, but that was one of the ones from the general participants, which was very important on the budget procedures and civil society's role. I'd like to turn over to Dean to make a comment and also in that respond to one question that we had on cabinet disclosure in New Zealand. And then I invite any other participants who want to say some closing words. Unfortunately, I would appreciate if you could keep it short. I hate to cut the discussion, but we're already over time. So.
Yeah, if I can sort of close with one innovation on democratic healthiness that I think a number of you wanted me just to clarify, because I think you're so envious, which is, yes, every month the government has been making available on the public COVID website every cabinet paper and minute that they've made, subject only to a few handful of redactions for a couple of reasons. It is a constitutional train spotter's dream. It's got full detail, hundreds of documents, modelling, key decision-making papers, contingency plans, and so forth. There has been some incredible journalism as a result, where some journalists have spent a week going through and pulling out all the key paragraphs, helping paint the narrative of the build-up and through the lockdown and how the government evolved. But I just think the power of transparency. We've got a PM who believes in transparency and democracy and taking a community with her, and also civil servants that have been building up this sort of generic approach to transparency about government decision making. But in a pandemic, it just helps in the narrative. We're all in this together. We're being open. It's just been really helpful in building that sort of high degree of trust and confidence in the decision making, because you get to see it, what was around the cabinet table. And I know you're all envious of it, but come move to New Zealand once the borders open again, because this is not pandemic specific. This is how the government is going to keep operating as in the future as well, we hope.
Excellent, thank you. Jaclyn, would you like to make any final remarks?
Sure. I think for me, obviously the pandemic has led to changes in terms of how some legislative innovations and so on. I didn't go too much into the type of legislation that was put in place. For instance, some of them are very much into private law type innovations, whereby you can seek relief from contracts and so on. So I think that what is key is we do see legislatures being very responsive, many legislatures being very responsive to the impact, the wide-ranging impacts that COVID-19 has on the people, not just in terms of public health, but also in terms of economic fallout and other sort of aspects. I mean, one of the big issues in Singapore was, what do we do about weddings? What do we do about weddings can no longer go forward? So they had to pass these regulations to deal with that type of situations. And can you still get married? Can you get married over Zoom, for instance? So these are sort of issues that governments have to deal with, these very, very sort of detailed but important issues. If you're getting married, you want to know whether you can do it over Zoom, right? And so on. But I just wanted to sort of maybe end with this by saying that in terms of accountability, I think one question that I would be interested in to sort of examine more carefully in the future is the impact on the expectations that the electorate have on governments, right? How is this changing their expectations of what government should be? Mm-hmm. How responsive do governments have to be? And how charismatic politicians have to be, because now we see, I suppose in many countries, our ministers who were in charge of the intergovernmental agency response they would have these press conferences every day, telling people how many numbers, what are the numbers, what's being done, and so on. So there is this sort of transparency that comes with having to do these press conferences. Then people start commenting about, oh, this person is charismatic, that person is not charismatic. And with the impact of social media, how is this changing our expectations of what is good government and who is a good governor? Thank you.
Okay, thank you. Then instead of making a closing remarks, I'd like to make some brief statements regarding the opposition's role, which Cheryl previously mentioned and asked about. The opposition's role is very critical and is very important in democracy and also the party democracy. But yeah, Jaclyn pointed that the election amid the pandemic could be a certain kind of test for the ruling party or the government But contrary to the Singapore experience, the ruling party of Korea had the victory, a landslide victory. So yeah, exactly. During the election campaign, the government and the ruling party tried to demonstrate their capacity to deal with this pandemic, how well they have been doing. But the opposition party also demonstrated to try to demonstrate how bad it is, how bad the government is reacting to the pandemic. But the voters choices were largely went to the ruling party and supported the ruling party and the government. There's some more reasons why the ruling party has a great win, but one of the reasons is undeniably the well performance during the pandemic of the government. So actually, under this circumstance, the current opposition party or minor parties cannot have a role to stop or to effectively control the making or amending the bill or any budget supplementary revised bill passing. But it will be also meaningful to present such an opposing view, to share with people, citizens, and to have a chance to criticize and to look at the government's performance with a critical view. So as I mentioned above, even in the pandemic, even during the pandemic and afterwards, it is also could be the useful information or views or opinions or the perspective to scrutinize or review, decide whether the government had done good or whether the government had abused its power or not. So even though they cannot control or they restrict any passing any bills passing or any budget passing, but it could be also important for now. Thank you.
Thank you. Unless any of the panelists feel well, or would you like to make any final remarks, or are you?
Sure, I can. That's all right. I think what Papua New Guinea has learned, and probably going forward with the COVID case, is that despite the fact that it has this current tension, or in terms of the legislation that has come about, and therefore undermining the state of emergency within the constitution, the other constitutional arms are at play. And so there is that robustness of the constitution still at play. The local governments are able to hold the national government accountable. The opposition is allowed that freedom to be very, very vocal in its role. I think there will be some conversations, perhaps looking at the reasons why the government decide to go with the act in terms of enforcing emergency laws and not the constitution. If the constitutional pathways are deemed to be, I guess, process-driven, then perhaps there might be some consideration about whether or not there should be some reform. But I don't think the court will be able to buy into that, considering their opinions on previous cases. It's quite hard to convince them. If this current case goes forward, that there should be some strong statements from the court in that area. The other thing to point out, I think the opposition's role at the early stages also raised the question of whether or not the Westminster system is a viable system. We tend to take for granted the sainthood of the Westminster system, but it has its flaws. And when countries have a very divisive, very, in some ways, very tense, and opposition that is quite combative. It does raise the question as to whether or not the Westminster system promotes social cohesion, promotes the goodness of the society, or in a way, allows opportunity to further create fragmentation. So I think the conduct of the opposition raises some of those questions, whether or not, and the PNG has considered before in its history whether it should adopt the Westminster system. And it's, with some quarters in the country, they're still deliberating whether or not this is the perfect system. So I think the conduct of the opposition will contribute to that conversation. Finally, there is a constitutional independence in terms of the government realizing that with COVID coming in, there is restriction on external personnel advising or running important portfolios in the country, and Papua New Guineans raising up to take hold of the country. I think there is a sense of national pride that COVID is reinforcing talent and I guess sense of nationhood, that you don't have to depend on external entities to actually effectively run your country. So, you know, when you have foreign judges not there, or when you have foreign lawyers not being involved in your justice system, and local experts, I guess, stepping up, that's another very, very important point, I guess, for Papua New Guinea and for many countries in the Pacific, that they are taking hold of their independence, and therefore, because there is that sense of national pride which can drive greater constitutionalism, I believe, in PNG and across the region. Thank you.
Excellent. Thank you so much. Wilson, I feel that maybe, do you want to speak, or do you feel satisfied by the last question? No, okay, great. Sorry, because we are really over time. I feel terrible keeping all of you. Thank you so much for joining us today. The good news is that the Melbourne Forum 2020 is still going on. Please do join us for our next sessions. We have a third session coming up next week on Thursday about multi-level governance, and then we'll finish looking at institutions, both international and domestic, in our last session on September 24th. In the meanwhile, please ensure that you do check out our papers and our website. We will be putting also a link to this on YouTube so you can share it with other colleagues in the future. And I really appreciate everyone's time. A big thank you especially to our panelists who prepared excellently for today. It was a very rich discussion, and I think we really recovered the Melbourne Forum spirit of interaction. So thank you to everybody, and we'll see you next time.